Fast track in court. Here comes the simplified civil procedure. As of 19th August 2025, a new court process is available in civil cases, the simplified civil procedure. Introduced as part of recent justice system reforms, this new process aims to offer a faster and more cost-effective alternative to traditional litigation, which can often take years. However, the trade-off for speed is that some procedural rights are limited. So, what exactly is this new process? When can it be used? How is it different? And who stands to benefit? Exclusively by agreement, with exceptions. One key feature of the simplified procedure is that it can only be used if both parties agree in writing. This agreement must be included with the initial claim submitted to the court. In business settings, it's common to include rules for future legal disputes in contracts, such as which court will decide or what law applies. In the same way, parties can include a clause choosing the simplified procedure, or they can sign a separate agreement shortly before going to court. However, the law excludes some cases from using this procedure. It cannot be used for family law cases, for example, divorce, paternity, consumer disputes, employment-related matters. This means the simplified procedure is mainly designed for contractual and business disputes, where both sides prefer a quick resolution. Shorter and more affordable path to judgment. The main advantage of this new procedure is its speed and lower cost. The case skips the usual two-phase process. Defendants have only 15 days, instead of 45, to respond to the plaintiff's statement of claim. Courts must generally act within 8 days, instead of 30. After the statement of defense is filed, only one more written submission is allowed, speeding the process up. After all written submissions, the court asks both parties whether they want to switch back to the regular procedure. If both agree, the case continues as usual. If not, the court issues a judgment within 30 days. As an important aspect, everything happens in writing during the simplified procedure. There are no court hearings, no witnesses, and no third-party involvement. This means fewer delays but also fewer tools available for complex cases. To reflect the simpler process, court fees are reduced to 70% of what they would be under the standard rules. Limited evidence and mandatory legal representation. Since there are no hearings, only written evidence is accepted. That includes documents and written expert opinions only, meaning that parties can't call witnesses or provide personal testimony. Expert evidencing is also restricted. Parties can't request a new expert or add to an existing report. Due to the limited tools, it's essential to collect the available evidence carefully from the start and present them appropriately in the first written submissions. To support this, the law requires that both parties must have legal representation. While this adds some cost, it ensures that the process stays professional and focused, helping both the parties and the court. Remedies: fast and limited in scope. Even though the goal is a quick process, parties still have the right to appeal, but in a more limited way. Appeals must be filed within 8 days, instead of 15. Appeals against judgments can only be made for serious procedural mistakes or wrong application of the law. Also, final judgments cannot be reviewed by the Curia, Hungary's highest court. Although this speeds up the process to a final resolution, but also reduces the chances for further legal challenge. Other options like retrial or constitutional complaint are still available. Is it worth choosing? This new procedure could be a great option for small and medium-sized businesses that seek a quick, cost-effective legal solution. Because lawyers are required in the process and only written documents are used, the simplified procedure stays professional but avoids long delays as well. However, it's not right for every case. If your case needs detailed evidencing or more flexibility, the limits of this process could be a disadvantage. Also, getting requiring parties to agree in advance, especially when a dispute already exists, might not always be realistic. Regardless, for simpler, straightforward cases, where both sides need a fast resolution, this new process could be a useful tool. Conclusion: based on the above, the simplified civil procedure combines voluntary agreement between parties with streamlined rules from other legal areas, like administrative court cases. It offers faster and cheaper decisions but limits the usual legal options available, which can be a disadvantage in many cases. The long-term success of this new procedural model is still uncertain. In the end, only practical experience will show whether it can truly serve the somewhat unclear role intended for it and whether parties are willing to trade some legal flexibility for greater speed and predictability.